Hello, and today we're going to look at carrying out investigations and disciplinary proceedings in relation to allegations of misconduct. Now, in practice, most managers are going to come across allegations of misconduct by employees that are under their supervision. So it's really important to be aware of what you need to do to ensure you're carrying out a fair procedure and ensure that's followed and you know what you need to do if things come up. Now, before I start, it's really important to look at the legal principles that underpin the advice I'm going to go through today. Now, those are the unfair dismissal legislation set out in the Employment Rights Act 1996, and that's looking at being aware of who can claim unfair dismissal, so employees who have at least 2 years service, the need to identify a fair reason. So there are a number of potentially fair reasons in the Employment Rights Act, but obviously the one we're looking at today will be that of conduct. And also, finally, the need to act reasonably in deciding to dismiss an employee and justifying that. Secondly, you've got the ACAS Code of Practice on Disciplinary and Grievance Procedures. Now, this is practical guidance for employers and employees as to how to carry out a fair disciplinary procedure. Now, employers aren't liable if they fail to follow that automatically, but what you need to be aware of is that if you don't follow the principles set out in the ACAS Code, and an employee brings an unfair dismissal claim or discrimination, and they are successful, compensation can be increased up to a maximum of 25% if you fail to follow the code. So do be mindful of that, and it's really important that any disciplinary procedure has that underpinning it. Now, if things arise, it's really important to think about whether formal action is actually necessary. Is a disciplinary hearing necessary? Think about that before you take any action. For example, if you've got an employee who's turning up late a number of times and you've observed that and you're not happy about it, take them to one side, have a confidential discussion about what the issue is, find out if there's anything underlying that you need to be aware of. Is there any health issue? That can be something that can nip the issue in the bud at that moment, and it's not necessary to take any formal action. The ACAS code actually encourages informal resolution where it's possible and also where it's appropriate. So think about that. It may well be a quiet word is all you need to solve a problem. If that's what you're going to do, it's really important that any warning that you give, a verbal warning, is strictly informal. It's not something that should be placed on an employee's file, and it shouldn't be taken into account if formal disciplinary proceedings are then taken. Now, it's not something you need to confirm in writing, and it's not something then that should be kept on file. But what you can do is, of course, make a note of it so that it's used for effective management. And if things obviously continue, it's then used as a reason to take formal action against the employee. In terms of suggested informal steps, as I mentioned before, have that confidential meeting to highlight the problem. Inquire as to why a problem has arisen. As I mentioned before, there may well be a completely normal explanation for it, something your employee hasn't told you about that they're struggling with, and that can be resolved without the need to go any further. Agree what action is needed and keep a record of that conversation for your own purposes for management of that employee. Make sure the employee knows what has been agreed, and you can set that in writing, although not as a formal warning, obviously, and make it clear that if things don't improve, disciplinary action will follow if there's no change. Obviously, that being said, informal action will not always be appropriate. And obviously, if something can't be resolved at the informal stage, or if something is just too serious for it to be dealt with informally, you will need to look at then commencing a formal process. What I would say is it's really important at the outset and also during a disciplinary proceedings to have a good understanding of the requirements and the stages of the process. And that will really help you ensure you've got the correct personnel in place to deal with what needs to take place. What I would say is be really be careful to ensure that there's no indication that an outcome has been prejudged. It's all about carrying out the investigation and making a decision once you've held that disciplinary hearing. In terms of planning, I'd say at its simplest, it's going to be checking the requirements of disciplinary procedure, check the policies you have in place, choose who's going to carry out the investigation, who's going to be that officer, ensure they know what they need to do, and if it's possible to give them any training, that's really important. Be mindful of the need to have different people for different stages. So if you've identified who your investigation officer is going to be, make sure you have someone in place who's ready to hold the disciplinary hearing, and also someone separately and impartial who's not been involved and is of the appropriate standing to hold an appeal should that be necessary. Finally, keeping in mind the timescales for policies, again, check your policies for any timescales that have been clearly set out. These things need to be carried out within a reasonable time frame, but also ensure you correctly frame the allegations so it's clear what the allegations are and what you are actually investigating. In terms of the allegation itself, as I mentioned, it's really important to frame that correctly, be clear of what you're investigating. Now, that's really important because the content of the allegation will really frame the investigation that you're carrying out. It's going to decide what you need to investigate, who you're going to speak to, what documents you're looking at. That's really fundamental. And because of that, it's really critical for the principles of fairness that the employee knows what the allegations are against them. So, starting the investigation. As you will be aware, investigation is absolutely critical when it comes to a fair disciplinary procedure. And if you're failing at that stage, you're certainly going to fall foul of the ACAS code and the principles of fairness set out in the Employment Rights Act. What I would say is before starting an investigation, think about a number of things. Think about how much investigation you're going to need to carry out. Think about what's reasonable. It's all about what's reasonable in the circumstances, and that's going to vary depending on the seriousness of the allegation, what you need to cover, who you need to speak to. It's all about what the allegation is. For example, there might be circumstances where actually you only need to speak to a couple of people. In other situations, you're going to have to go through a number of policies, look at CCTV, speak to a number of witnesses, check training records, think about what needs to be carried out. Who's going to conduct the investigation? Again, as I mentioned previously, have someone ready, but make sure that you've got the person who's ready to hold the disciplinary and also the appeal, so you've got 3 separate people ready to deal with those matters. What's the role of HR? I mean, you may have your own individual who's responsible for HR. Usually, obviously, that will be the practice manager. It's really important that the role of HR is clear. They should only really be providing guidance in terms of process and legal principles. They shouldn't be involved in actually carrying out the investigation. That's the role of the investigatory officer. So be clear as to what the roles are. If there are issues with that, that can obviously cause problems with the fairness of the procedure. With investigations, it's important also to note there's no statutory right to be accompanied as there is a disciplinary hearing. So if that request is made, that is something you can consider. What you need to be careful of is obviously if an employee is disabled, then you will have the duty to make reasonable adjustments, and do bear that in mind. In terms of some final points, do bear in mind the importance of confidentiality. When you're speaking to the employee, but also your witnesses, remind them of that duty and that there could be disciplinary proceedings if they fail to follow that. Confidentiality is really important. It can have a massive impact on your employees in the workspace if things are not kept confidential. It can have a really big impact on morale. And there's also that huge risk of witnesses speaking to each other and agreeing their story before you've actually spoken to them. So it can really impact on the fairness and how an investigation is carried out. Finally, obtain that evidence without unreasonable delay. You really need to speak to people before memories fade so that the evidence you collect is clear and you have as much information as possible. What about covert surveillance? Again, real care should be taken when you're looking at covert surveillance. You have to be really aware of the rights to privacy and that there aren't any issues in that regard. Think about whether it's really necessary to look at CCTV footage, what information is being given, are employees aware that there is CCTV there, and ensure that you're complying with your legal requirements in that regard. In terms of things like private electronic messaging, like WhatsApp, things that are coming up now, do be careful again if you're looking at this and this comes up. I mean, the case law at the minute suggests that individuals who are using this kind of messaging services have a reasonable expectation of privacy. So that has to be a starting point. What I would say is there will obviously be issues if an employee is of a particular professional standard and they've got standards they need to adhere to, or they're subject to a particular code of conduct. Examples of that might be, for example, the police. What about if you're wanting to speak to witnesses and they're reluctant or they want that anonymity? Now, obviously, as we've mentioned previously, witnesses are going to be crucial to your investigation. I think if you've got witnesses who want to remain anonymous, look into the reasons for that, explore those reasons. It's really something you should try and avoid if possible. And it's really only going to be exceptional circumstances when there's a genuine fear of reprisal if someone gives evidence. What's really important is to remind your employees of the duty of good faith and fidelity in terms of their cooperation. If someone really doesn't want to give their name, it's going to be really difficult to force them not to do so unless someone's of a particular senior position where there's that obligation that comes with that role. Do think about the contractual rights of the person being investigated. There's that real importance of the balance between the rights of the employee and the need to investigate. So it's really important that you only carry out investigation that's necessary. Do remember that investigation meetings are not disciplinary hearings. It's all about you gathering that information. Don't comment on your feelings about someone's guilt. And there is always that need for a disciplinary hearing, even if someone admits guilt at the investigation stage. So the disciplinary hearing is a separate hearing that needs to take place. When you've finished, it's really useful to put together an investigation report. That really provides a summary of the steps you've taken and also a summary of the evidence that you've collected. There can be recommendations in there, but be careful not to give any conclusions. The role of the investigatory officer is not to bring a conclusion in terms of whether an employee is guilty. That's the role for the disciplinary officer. It's all just about gathering information and putting that forward for the disciplinary officer. Finally, once you've finished your investigation, think about the purposes of it. It's there for you to decide, is there a disciplinary case to answer? It's not always going to be the case that there is, so it may well be that there's been a clear explanation as to what's happened and then no further action needs to be required. If that's the case, you simply bring the matter to a close, you inform the employee, and that's the end of that. If you then do need to take things forward, again, you need to be clear as to what the allegation is, and you then need to take steps to arrange a disciplinary hearing. In terms of what's going on in the background, it may well be appropriate if the allegations are particularly serious to suspend an employee. And what I would say is you really need to be careful and to consider whether it's actually necessary. It should only really be necessary when there's a threat to the business. If an employee remains in the business, for example, if the allegation is really serious and if they are guilty, it's not something you can take the risk of, and there needs to be safeguards put in place, and suspension is the only thing that is possible to safeguard the business. Or if it's going to really hamper you carrying out a fair investigation, for example, they're going to speak to witnesses or they're just going to be in the way, and given the nature of their work and the working environment, it's not going to be possible. So think about those things. Ensure that if there is a suspension, that it's as short as possible. The decision is kept under review, so it's not that you can just put someone in suspension and leave it at that. You need to keep that under review and check that it's still necessary. It may well be that it's possible to bring them back to work. It's also really important to make it clear what suspension means and that it's not disciplinary action. So set out the terms clearly of what they are and aren't allowed to do, who they need to contact, who they shouldn't be contacting, and make it clear it's not a disciplinary sanction. It's really important to check as well that you've got that contractual entitlement to suspend. Check your contracts and your contractual policies. Do really be mindful of breach of trust and confidence. There's a real risk that if you just have a knee-jerk reaction to an allegation, suspend someone without even thinking about it, you're going to be in breach of the duty of trust and confidence. So really think back. It goes back to what I mentioned earlier about thinking about, is this really possible? Can other things be put in place, other safeguards to avoid suspension? Can we move them around? Can we separate who they're working from? Can we buddy them up with someone? Think about those options. Suspension should be on full pay unless there's an express right to do so, which will be rare. It would need to be on full pay for that period. Do be careful about how you apply suspension. It needs to be applied consistently, otherwise you risk exposure to discrimination, especially if there are issues with regards to someone being put on suspension and the reasons for that. And if there's any argument that reason is to do with someone's protected characteristic, then you do expose yourself to the risk of discrimination claims. Just on a final point, sickness absence, it comes up as an issue. If someone's suspended and then they actually call in sick, it's not so easy that you can just move them on from full pay to statutory sick pay if that's all they're entitled to. You do need to be mindful of that, and I would seek advice if you're in that situation before you take that step. So you're at the point when you're inviting an employee to a disciplinary hearing. It's really vital that you set out particular information to them so it's clear as to what they're dealing with. Firstly, I would set out the case against the employee. It's really important they're aware of the charges against them. They're given that opportunity to respond, and each side has the opportunity to put forward their story. Also ensure they know what the severity of the allegations are and what the possible consequences could be. An employee needs to know if they're fighting for their job, and that's where it's going to be vital that you set that out in an invitation so there's clear evidence of that. Finally, disclose the evidence that you've collected. Employees need to be given copies of all witness statements, all documents that you as the employer are going to rely on as part of the proceedings. And make sure they've got enough time to go through that evidence ahead of the disciplinary. That's why we'd always say you need to give at least 48 hours notice with the evidence for someone to properly consider and prepare for the hearing. So you're at the disciplinary hearing itself. Things to consider are, and things that can come up that cause issues, are non-attendance and request to postpone. Now, you often get employees who will ask for more time. They either say they're ill or they're not available or their companion's not available. Now, I think if you've got a first request for a postponement, do agree to that. But then if you're in a situation where there are persistent postponements or there's no good reason for the requests, then you're in a situation when you can proceed to hear the disciplinary on the evidence you've got without them being there. You can also ask and ensure you do so for them to give written reasons or a written representation. What I would say is, looking at ill health and stress, you can often end up in a conflicting situation if someone says that they're not fit, they're dealing with, they're stressed by the situation. You've got two conflicting priorities there. You've got the issue of needing to deal with the matter speedily, but then you've got the other side of the coin where the employee simply might not be well enough to attend. In that situation, you really need to get medical opinion, because that's not a decision you could make, and see what they've got to say. I mean, someone may not be fit to attend work, but it doesn't mean they're not fit to attend a disciplinary hearing. I think holding the hearing in an employee's absence, that again is something you're going to have to get an occupational health or a doctor's opinion on. That might give some clarity as to whether someone is fit to attend or not. And if it's something that needs to be dealt with, action may need to be taken in terms of hearing that in an employee's absence. Who should be chairing the hearing? As I mentioned earlier, there should be a clear person who's holding the hearing as the disciplinary officer. It should be someone who wasn't involved in the investigation and is also of the appropriate seniority. Finally, keep a record of the meeting, so have someone separate who's simply there as a note taker, and you make the employee aware of that. At the start of the hearing, in terms of what to go through, introduce yourself and remind the employee of the right to be accompanied. Make sure they've made that choice. If there is an issue, it may be appropriate to adjourn at that point, and I would always advise that you do so if something comes up. Again, go over the documentation that's been provided and check that the employee has received that and had the chance to go over it. Always check for reasonable adjustments. If you have an employee who's disabled, check they're comfortable and they're ready to proceed. Go over the allegations and the evidence again, and then invite the employee to ask questions. Make sure they've given the reasonable opportunity to present their version of events. When you're finishing off and there's no further questions and everything has been said by the employee, summarise what's been discussed and request any clarification. Check they've said everything they want to say before you close off the meeting. Once you've done that, do adjourn the meeting, whether you've got further investigation to carry out or not. It may well be that you've got further questions to go through. It may well be that you've finished, you've done everything you need to do. You may well have actually made your decision. But even if you've done that, I'd certainly advise that you adjourn the meeting to go away and make a decision, even for 10 or 15 minutes. And then it's clear that you're going away to consider what's been discussed. In terms of cross-examination of witnesses, there's a bit of a dispute at the minute as to whether it's something that should be allowed and whether that should be refused if an employee asks to cross-examine a witness. What I would say is it's really probably only going to be reasonable in a case where someone's guilt comes down to a particular point where there's conflicting evidence and it's going to come down to cross-examination. That will be exceptional circumstances. You really need to consider whether an employee will be disadvantaged by a refusal to do so. It's really important to be aware that the tribunal and the appeal courts emphasise the fact that disciplinary hearings shouldn't be quasi-judicial proceedings, so it's not a court case. But think about whether it's appropriate. What about excluding an employee from part of a hearing? If a witness wants to give evidence they're not comfortable with the employee being there, what I would say again is it's only going to be reasonable really when an employee is concerned that they're going to feel intimidated or frightened. And what I'd say again is that you've really got to check whether an employee would be disadvantaged by that. It could be the case that you allow the companion to stay, but again, it's going to need careful consideration. Think about the right to be accompanied. At disciplinary hearings, employees have the right to be accompanied by a trade union representative or a colleague, so make sure that they're aware of that right. They don't have the right to be legally represented, so if that's requested, it's not something you have to provide for them, and it's not usual in practice. What about matters involving the police? Now, this can be an issue. Is it the case that you have to put things on hold while you wait for a trial outcome? I mean, what I would say, it's not something employees would usually want to do because it can take time and you're going to have an employee who's on full pay during that period. What's useful is there is some case law which gives some guidance on some relevant factors that would be taken into account when asking this question. So you're going to be looking at the impracticality of you waiting as an employer, the size of your business, terms of the contract or disciplinary procedures. There isn't a rule that says employees can't dismiss if an employee is pending trial and they've been advised to make no comment. But it's really going to be important for the employer to give the employee the opportunity to respond, even if they might decide to give no comment, and it's made clear that dismissal is on the cards. What about the level of investigation into criminal allegations? I mean, at times it's not going to be appropriate to have an internal investigation where a trial is pending and that trial might be prejudiced if someone makes an admission. Now, there's no general rule that employers can't dismiss someone without a hearing when there's a trial pending. But what I would say is you've got to think about that test for fair dismissal when it comes back to misconduct. You've got to have that reasonable belief in an employee's guilt, and that belief has got to be based on a reasonable investigation. And that's set out in the BHS and Birchall case. So it all comes back to that, and think about the situation you're in those circumstances. What about relying on police investigation? Can you do so? Now, the non-statutory ACAS guidance suggests that employers should always carry out their own investigation. But if you've got police investigation that uncovers wrongdoing by an employee, there's nothing stopping you relying on that if it's provided by the police. What about if someone is acquitted following trial? Well, what's important to be aware of then is that you're not bound by the outcome of a trial. There may actually be cases where an employee might be acquitted or proceedings stopped or discontinued, but it may well be appropriate for you as an employer with the employee-employee relationship to continue investigations. Remember, there are two different proceedings. They're underpinned by different legal principles, so they're different situations. Finally, when might it be appropriate to involve the police? When considering this question, I think you need to be really careful not to subject employees to the heavy burden of criminal proceedings if it's not appropriate. You need to really give it careful consideration, and it's only going to be in the cases where you have a real genuine belief that the allegation raised is something that will likely amount to a criminal offence. So do bear that in mind. Right, so you come to the end of the disciplinary hearing and you're making that decision. When you're doing so, you need to think of two things. You're either upholding the allegation, and if so, what sanction are you imposing? So you're finding them guilty of that misconduct. What is the sanction that you're going to impose? Is that going to be dismissal? Is it going to be a warning? If you're looking at dismissal, again, that's only going to be in situations where it's gross misconduct or someone's on a final warning already. So you've got to go back to think about the fairness requirements under the Employment Rights Act and also the ACAS code. Have you got a fair reason, and is it reasonable to dismiss in the circumstances of the case? Go back over those principles. If you're giving a warning, what kind of warning are you giving? What is the chance to improve? ACAS code recommends at least one chance to improve before you give a final written warning. So do bear that in mind. Think about the length of the warning. There's no general guidance set out, but in practice, you'd generally be giving 6 months for a first warning, 12 months for a final written warning. And if you've got someone who's persistently getting into issues once their warnings have lapsed, that can be the kind of situation when you might put someone on a more permanent warning. What about if an employee is on maternity or sick leave when they're subject to disciplinary proceedings? Now, you're not prevented from doing so when someone is on maternity leave or sick leave, but what I would say is, for example, if someone's on maternity leave, if you're extending a warning until they come back, that's likely to amount to unfavourable treatment because of pregnancy and maternity, and that's going to amount to discrimination. So best course of action in that kind of situation is wait until they return to work and address any new issues that arise at that point, if they do. What about demotion or other sanctions? Think about, have you got that contractual right? If you're deciding to demote, have you got sufficient reasons to do so? If you don't, you could end up exposing yourself to being in a breach of contract situation. check your policies and procedures. Communicate the decision. That has to be done in writing, make it clear and without unreasonable delay. In terms of warning letters, you need to set out the allegation, the findings, the basis of those findings, refer to any previous warnings, set out the period of that warning, where it's going to be kept, and the right of appeal and the time frame for doing so. Similarly, with dismissal letters, you need to set out the decision made, the basis for that, the reasons for that, any mitigating factors you've considered, again, the right of appeal and the time frame, when the termination date is, set out the details in terms of payments they'll receive, and so they know exactly what's happening in that regard. Finally, in terms of disciplining twice for the same conduct, again, it's going to be exceptional circumstances when that can be justified. Coming on to appeal, we talked about giving the employee the right to appeal, and that must be done in the letter confirming the sanction that they're given. If an employee does appeal, you need to have someone, as we mentioned earlier, set aside ready to hear that. It needs to be someone who hasn't been involved previously. It may be that in your business you haven't got someone either sufficiently senior who hasn't been involved so far, given the nature of the allegation. And it may then be appropriate to engage an HR consultant who can hear the appeal from an independent and impartial perspective. That's something that a lot of employers do. In terms of procedure, you need to ensure and require the employee to set out their grounds of appeal in full, and then you need to decide whether it's appropriate, given the grounds of appeal, whether you are just reviewing the decision or you're conducting a full rehearing. There's no obligation to have an external appeal panel, but a lot of employers do, and it may well be appropriate to have an independent panel, given the nature of the profession. What about new evidence? If new evidence comes up, make sure you give the employee the opportunity to comment. If you don't, it's going to have an impact on fairness. It is something that can be taken into account, and it can justify dismissal, even if the evidence wouldn't have justified it at the first instance. Finally, what about increasing the sanction? It is possible to do so if you've got the contractual right to do so, but what I would say is you've got to be really careful. Appeals shouldn't be used to punish employees, and we've really got to be careful that it doesn't then become a deterrent if there's that risk of the sanction being increased, that it doesn't prevent an employee appealing in the first instance. Just on a final note, really important in disciplinary proceedings to keep records. That's a record of the allegation details, the sanctions, the investigation that was carried out. Keep copies of correspondence, notes of all of the hearings, and the rationale for decision made. That's really important. So, for example, if an employee brings an unfair dismissal claim, you've got all of that contemporaneous information ready as evidence, should it be necessary. In terms of covert recordings, in terms of admissibility at the tribunal, if an employee was present when those recordings were made, they would be admissible. If not, then there are issues in that regard. So it's all about whether someone is aware that they've been recorded, and vice versa for an employer. In terms of retention and data protection, you really need to ensure that you're complying with data protection legislation. It's really important that you only retain and use documentation in connection with the principles for which you've obtained it. And once that's concluded, you retain it for no longer than is needed. So do bear that in mind when you're processing personal data. That's been a general overview of carrying out a disciplinary investigation and hearing. If you do have any questions, please do not hesitate to get in touch. Thank you very much.